From the very start, this hearing isn't really about a single missed court date. It's about power, professionalism, and what happens when emotions spill into a system that depends on restraint.
This is file number 25760FY, People versus Courtroom Fuller. That's you, sir?
Yes, sir, it is.
You're here with your lawyer, Mr. Ross Truckee.
Yes, sir, I am, John.
This matter is set for a pre-exam conference this morning. It's got some history to it. It was set for a preliminary examination on the 20th of May, I believe the date was, and you didn't show up. So you should have bench warrant for your arrest. You presented yourself in court on the 28th, and I recalled the bench warrant and scheduled the matter for this morning. I asked for a special hearing regarding Assistant Prosecuting Attorney Gary Gabry. His boss, Deborah Davis, is here. Ms. Davis, is Mr. Gabry going to be present?
Your Honor, he's next door doing the sentencings with Judge Pattison. So it wasn't clear from the email what exactly we were going to be covering.
He was extremely disrespectful to me. He walked into my chambers, called me disgusting, stomped out and disagreed with my recalling the bench warrant in this case, which is a violation of the canons of professional ethics and a great insult to me. He also was wrong on the facts and the law. So
what matters here is something most viewers never hear about. Court rules don't care about emotions. The judge didn't go easy on anyone. He followed the law exactly as written, even though he admits judges hate this rule.
He was charged with this. Preliminary examination was set for May 20th. The defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. There was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day and said, in the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. He didn't show up on the 20th. Then he presented himself at the court. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He went to the jail and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor.
So you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. Mr. Truckee walked out the door, and you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are. I canceled your bond. It was my bench warrant. And there's a statute that nobody likes, but it's MCR 6.105. It's actually a court rule. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond.
This is where things turn explosive. A prosecutor, someone sworn to uphold the system, allegedly storms into a judge's chambers and calls a ruling disgusting. That's not disagreement. That's crossing a line.
That morning, Mr. Gabry came into my chambers. I was in there signing some orders, and I said, hey, good morning. I got something I'd like to talk to you about. I had a misdemeanor complaint that was handled by their intern that I wanted to check with him on. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Karan Fuller a PR bond? I didn't have an instant response. I just recalled the bench warrant. I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up. And I cited the court rule. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, "This is disgusting," or "You're disgusting," and he walked out of my office. This was ex parte. Nobody else was in there but us. And so I left sitting there thinking either maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel this bond because Gary Gabriel is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to...
Judges don't usually talk like this on the record. When they do, it means the courtroom itself feels threatened. Respect isn't about ego here. It's about keeping the justice system functional.
Aware of Mr. Fuller attempting to turn himself into the jail. But that's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We had made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to the system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous, with fleeing and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history and not showing up, I'm thankful that the court is going to have a test done.
Well, let's assume that all that is true. What gives him the right to come into my office and express his disgust for my ruling?
Your Honor, I don't believe that it's not appropriate. I get that. We are in a very difficult situation in our office in light of everything that has happened in the last year and a half. So it's been very difficult. It's been very stressful. And I think overall, Mr. Gabriel has the same philosophy that I do as far as holding people accountable and taking action so that people know that if they do get...
The prosecution raises serious concerns about public safety, and those concerns aren't fake. But the problem is timing and method. You don't fix system frustrations by attacking the judge personally.
Well, there's 2 sides to every story.
Correct, and there's perceptions. So I know that Mr. Gabriel apologizes for the...
I don't want to hear...
Thank you.
Mr. Gabriel.
First of all, let me say without any equivocation that I apologize for losing my temper, for addressing you more as someone that I have known for my entire career in criminal justice, someone who, with me, taught a number of even elected prosecutors right now how to try a case, how to be a prosecutor, what the ethics are involved in prosecution. In my 45 plus years, I have never been held in contempt. I have never disrespected the court when on the record. I have always prided myself on not only doing the right thing as a prosecutor, but also protecting the community's interests and law enforcement's resources. The comment that I made to you would never, Your Honor, and I think you know this because you and I know each other, our wives know each other, we've spent time on Mackinac, would never indicate my disgust for you as a human being. I have the utmost respect for your career. I do, however, differ with some of your handling of matters, one of which is your live stream, and you were aware that I took an opinion about that. The last time I was here, I still come to court when I can. I was brought in here to handle circuit court with the idea that this office might be able to get back where it should be before the last prosecutor dismantled things with his blatant accusations against my present boss. That's why I'm back here, because I believe in this prosecutor. I believe she's the first one you've had in a while that wants to do the right thing. And the right thing, just like it was the first time I was here for a while, was to hold the people that are putting a huge burden on the citizens in this community, to hold them accountable. My anger and my disrespect was directed towards a feeling that I have that this court expects a lot of its prosecutors to be here, to just wait, to address things that, as I just conveyed to the chief judge, one of the few counties I've ever been in as a prosecutor or a defense attorney where prosecutors appear routinely at sentencings. It just doesn't happen anywhere else. Why? Because they're busy. Well, we're busy. We have 3 people. One of them is the elected prosecutor, the newly elected prosecutor, who has her hands full just trying to correct the errors of the past year. That leaves me handling circuit court and helping out in district court, while Mr. Robert is helping out in district court and also spending a lot of time in Three Rivers. So yes, there is a lot of pressure on this office. Did that enter into my feelings of disrespect for how this system operates? Yes, it did. It was never directed towards you, Judge Middleton. There are times when I lapse and I have to think to myself to say Judge Middleton, because we've known each other a long time. I will, if I can, be honest now. Not that I haven't been up until now. You will recall that while at that prelim, I came in here and I advised the court right away that I had been working and trying to get Mr. Truckee to let me know whether Mr. Fuller was going to waive or not waive, that I had talked to Mr. Truckee about what would happen if I'm going to have to bring officers to come in and sit as what you call kind of so what case. Well, they came and they waited and they waited and we waited. I looked at this young man's record, this 34-year-old man. And I saw bench warrants just like this on the Walmart case and the stolen car case, where he was supposed to be here. And it got adjourned, come back. I think Rhonda Ives, nope, no bench warrants issued. In this situation, what happened from our perspective that day, I appeared at the prelim. I respectfully laid out why I thought it was appropriate that his bond be canceled, that a bench warrant be issued so that he could be brought before the court. And I knew he was going to get another bond, or at least we might find out, A, is he around? People assumed he was. I don't assume anything. All I know is he was supposed to be here. You did a bench warrant. I checked when you were gone because Mr. Robert pointed out the ROA was confusing, that it sounded like he was to be something about arrest, but the warrant was there. So I talked to Judge Pattison. We went to the district court. We clarified the day before he walked into court that the bench warrant was valid. Mr. Truckee had told him to go to the jail, and I knew nothing about him coming in here. Certainly knew nothing about him going to the jail. I knew nothing about him coming into the court when there was a warrant, and nobody in security had notified us. What I was notified of was when my prosecutor walked in that morning and said, I just saw Karan Fuller riding a bike or something down the street. What's going on? So I go up to security and they tell me, oh, he came in and Judge Middleton let him go. That upset me. It upset me because I thought that because of the respect that I've always shown this court, my willingness to try to be here to do what I can to help out, that I would have been notified of something when I'm sitting in my office looking at my cases. I want to know why he wasn't here. That's usually what happens in circuit. They get arrested. Why were you here? Well, my mother was sick. Okay, we'll reinstate the bond. Something to impress upon people that the court means business. And that's all I ask as a prosecutor, that the message that gets sent through this live stream, through our appearances in court, means something. Not comments like on the record, well, it's not the crime of the century, or it's a pain in my neck
He said he's a
when this
pain in my neck,
happens. Pardon me?
Yeah, he is a pain in the
Right.
neck.
But he's more than that, Your Honor. He shows disrespect to you, too. Your statement that you made about, well, it's more trouble to book you in and then book you out.
That's true.
It is. It is. But that's the system that's in place,
All right,
isn't
listen, I agree with everything you said.
And let me finish, and then I'll take my admonition. I do not recall that you ever indicated, or that I indicated a PR bond. I didn't know what happened. All I knew is you let him. They told me that you let him out. I didn't hear the court rule cited whatsoever. That, I think, would have been the thing that we might have done on the record had he been brought in and Mr. Truckee held here or held in the jail and held in lockup until Mr. Truckee got back, because I'm interested to know what kind of contact, if any, he even had with his attorney after he walked out of here. Those are the kinds of issues that go into my decision on whether I'm not going to use additional resources to just simply file a motion in front of Judge Stutzman and bring Ms. Ives in and bring everybody else in because of the multiple attorneys that get involved here. So there are a lot of things that I like to discuss. And I think if you talk to the chief judge, you'll hear that we talk about ways to try to improve the system, to try to make it more efficient, to try to make it work with just three of us. So yes, I was angry. Yes, I regret my comments to you, and I regret losing my temper. I don't want to be seen as that way, but I have been doing this for pretty close to 50 years, and I've seen it all. And I've been a judge dealing with parolees going back in front of me on the pro board. I know what it is to disrespect someone, and I feel bad that I did that, and I feel bad that I did it to somebody that I, in the past, considered a friend. I hope you will accept my apology for that.
This apology is complicated. You can hear decades of pressure, exhaustion, and frustration pouring out. It's human, but it also shows how thin the line is between passion and misconduct.
Is not being treated seriously, and for that, I apologize.
All right, your apology is accepted.
Thank you.
Within the week, Judge Pattis and I had a discussion just before I went on my trip about what an asset you were to the prosecutor's office. You can try a case in circuit court. You're willing to do misdemeanor pretrials. You show up at sentencing and do appropriate, thoughtful comments. Judge Pattis and I both believe, I'm sure Judge Stutzman too, that you're an asset to your office. The office wouldn't function without you being there. You and I go back 45 years, which is in part why you thought you could come in there and unload your anger on me. Yes, we taught a generation of young prosecutors how to be a prosecutor, including our current attorney general. But this case isn't the one to hang it on. Now, we'll have a drug test, and I have my suspicions of how that's going to turn out. And we'll have a prelim, if necessary, on Friday. When all the cases are in circuit court, perhaps you can file a motion to cancel this bond.
I will.
But that's up to Judge Stutzman, and he's got multiple counsel. I think there was an effort to try to do everything together. Anyway,
Your Honor.
The judge accepts the apology, not because the behavior was okay, but because accountability was taken. That's restraint. That's leadership.
with this, I don't think it deserves a grievance. All I wanted was an apology, and I got one.
Judge Middleton states that he does not think the issue deserves a quote-unquote grievance, and that he will accept an apology from Mr. Gabry instead. A so-called grievance is a formal report of suspected attorney misconduct to Michigan's attorney discipline system. Under Chapter 9 of the Michigan Court Rules, anyone, including a judge, may file a request for investigation with the Attorney Grievance Commission if they believe a lawyer has violated the Michigan rules of professional conduct or otherwise engaged in attorney misconduct. Once a grievance is filed, the commission investigates the allegations, and if the complaint is found to be credible, the attorney may receive an admonition or be placed on contractual probation, or formal charges can be filed with the Attorney Discipline Board. The Attorney Discipline Board is the adjudicative body authorized to impose discipline on lawyers who engage in misconduct, with penalties ranging from a reprimand to suspension or even disbarment. Accordingly, when Judge Middleton stated that he did not believe that the issue deserves a so-called grievance, he was indicating that although Mr. Gabri's actions could technically be reported and investigated as a violation of the professional conduct rules, he would not pursue formal disciplinary action and would instead resolve the matter informally by accepting an apology.
And the case will move forward, and the defendant is here as under the court rule. And I said, nobody liked that court rule. It was probably the least popular in the whole criminal justice reform package. But I'm bound to follow the law. Yes?
You had mentioned the prelim on Friday.
Excuse me, I'm sorry.
Okay, just want to make sure.
No, Tuesday, I don't want to make any further confusion. Tuesday, June 17th, 1 o'clock, Mr. Fuller, you're to be there at that time. I want you to go directly from me. Well, I'm all screwed up. June 10th, next Tuesday,
All be on the same
June
page.
10th, not the day we've been using for the others. I want you to go to the day reporting center right now, and we'll do an 11-panel test. We'll figure out who's going to pay for it, but it'll be paid for.
Yes, sir.
It may take a few days to deal with that. We'll deal with the results of that at your prelim next Tuesday. All right, you're free to go. We'll let the day reporting center know that you're coming. Laura, will you call them and tell them Mr. Fuller's going to stop there for a 11-panel urine test?
Thank you, Your Honor.
Thank you, Your Honor.
This case isn't about who won. It's about how fragile the justice system becomes when respect breaks down. Even the people enforcing the law have to follow it, especially when emotions run high.